Our class, the class that Professor Bonner and Pease and I taught winter term, which is just finishing now, went down to Washington, I should note, to see the re-argument down there. We went down on a bus. Was it about 30 hours down? No, it's about 20. I said somewhere between the Hudson and the Chesapeake, we stopped being a class and started being a team. But alas, it is a class, and our students have been writing papers on Daniel Webster and the Dartmouth College case. And we really wish that we could introduce you to all 35 students in the class. But alas, we don't have that much time. So we really just we invited 4 students to say a little bit about their papers. And we'd like this august panel to grill them appropriately. Hold nothing back, isn't that right? And what we'll do is I'll invite each student up, Josh Cowderer, Margaret Cross, Matt Sharon, Rachel Inman, one at a time, to make to present the core, the soul of his or her paper, and then we'll pause and entertain comments and questions from you, and give the student then a chance to respond before turning to the next student in turn. So we'll move relatively rapidly. So Josh, let me invite you up, please. Welcome.
Thank you. Hi, everyone. I'm Josh Cowderer, as Professor Muirhead said, and I'm a class of 2019, so a senior. And I wrote my paper on Daniel Webster and Abraham Lincoln as refounders of American Union. So the end of the Mexican-American War in February 1848 intensified a political war in Washington over the expansion of slavery into the newly acquired territories in the West. In August, Massachusetts Senator Daniel Webster, who maintained a lion's share of respect in the North for both his legal brilliance and his adherence to the Constitution, opined that slavery should be contained. Quote, "I shall oppose all such extension of slavery at all times and under all circumstances, even against all inducements, against all compromises." Webster's stance was consistent with the spirit of the 1846 Wilmot Proviso, seeking to limit the expansion of slavery. Many Southerners, on the other hand, saw the vast lands of the West as ripe for the peculiar institution. In 1850, the debate over the expansion of slavery continued. Henry Clay, a senator from Kentucky, developed a compromise to satisfy the North and the South. That compromise included that all states would be required to enforce the Fugitive Slave Act. The response to the compromise was hardly positive, and instead invoked backlash from both sides. Massachusetts intellectuals and reformers were outraged at the compromise's inclusion of the Fugitive Slave Act. Thoreau declared that the act's, quote, "natural habitat is in the dirt," and was willing to let Massachusetts, quote, "dissolve her union with the slaveholder before recognizing its legality." Some Southerners, too, rejected the compromise. Calhoun wrote in 1850 that, quote, "disunion is the only alternative that is left." The question that laid before the nation, therefore, was whether Webster, a devout supporter of union, would support Clay's compromise or let a turbulent political climate become unresolvable. Webster noted the gravity of the situation in 1850, writing, quote, "I thought the inevitable consequences of leaving the existing controversies unadjusted would be civil war." On March 7, 1850, Webster had made his decision. Speaking on the floor of the U.S. Senate, he announced his total support for the compromise because the preservation of the Union was his top focus. Webster abandoned his 1848 remarks opposing slavery's expansion and declared that all Americans should obey the letter of the law, even in the case of the Fugitive Slave Act. He received no applause for his willingness to compromise, soon to become overlooked by his party and a scorned man among his constituency. Over a century later, in Profiles of Courage, John F. Kennedy, also a Massachusetts man, argued that Webster's plea for the nation to compromise and, quote, enjoy the fresh air of liberty and union was an act of great sacrifice. Quote, Daniel Webster preferred to risk his career and his reputation rather than risk the Union. It was his greatest act of courageous principle. Kennedy's 20th century Webster was a man who compromised for a reason, to save his country and its precious Union. So, the question that arises is, how was Webster's legacy revived after the 7th of March speech that rendered him infamous among many of his countrymen? The answer that I have to that question is that another lawyer and defender of union, Abraham Lincoln, inherited Webster's conceptions of liberty and union and revived his legacy during the Civil War. Webster's views on liberty and union informed Lincoln's own political philosophy and served as the bedrock of his opposition to secession. Webster and Lincoln were ardent defenders of union as a tangible legal concept. Union was not mystical in the minds of these statesmen, but rather it alone enabled the United States to thrive. Law historian Robert Ferguson explained that lawyers made good politicians, writing, quote, certainly the politician depended on the lawyer. Always and on every level, Webster's answer lay in the law. Ferguson dubbed Lincoln the, quote, last Blackstone lawyer to lead the nation, arguing that he was influenced by Webster's devotion to the Union and understanding of government. Webster's legal foundations of union that he elaborated on in his reply to Hayne shaped Lincoln's own unionism. For Webster, quote unquote, we the people, those three words, were a remarkable phrase that linked the constitutional powers of the federal government directly to ordinary citizens. It was, quote, the people's constitution, the people's government, made for the people, made by the people, and answerable to the people. Words that you can link directly to the end of Lincoln's Gettysburg Address in 1863. In sum, for Webster, the Union was not an abstraction. Rather, it formed a single national government held accountable by the people and traceable back to 1776. Lincoln admired Webster's unionism, announcing to a crowd in Peoria, Illinois in 1854 that Clay and Webster were, quote, great men, men of great deeds. They were greatly devoted to the Union. In 1861, liberty and union were both under siege when several southern states seceded. These states drafted a constitution for the provisional government of the Confederacy, which emphasized that, quote, we, the deputies of the sovereign and independent states, formed the basis of the Confederate national government. Notice that that was not we the people, it was we the deputies of the sovereign and independent states. In his first inaugural address, Lincoln echoed Webster's sentiment and challenged that of the Confederates, arguing that, quote, no state upon its mere motion can lawfully get out of the Union unless my rightful masters, the American people, shall in some authoritative manner direct the contrary.
Josh, can I stop you right there and just ask you a question? First of all, I loved reading your paper. It was really well written, really interesting. It was clear to me, it's a mostly descriptive paper, obviously, but it was clear to me that you felt that what Abraham Lincoln did to revive Webster's reputation was warranted. But I wonder, having lived with this issue as you wrote the paper and through the course, do you agree with President Kennedy? Do you view what Webster did as a great act or not? I just wonder how personally you feel about that.
Sure. So,
easy question.
Yeah, of course, yeah. And I have thought about this quite a bit. And I have come to agree with Kennedy. But I agree with Kennedy in that I think what Lincoln did was perhaps the most noble thing to do in 1854 in Peoria, where Lincoln opposed the fugitive, or said that the Fugitive Slave Act needed to be obeyed because of, he prioritized saving the Union. But at the same time, Lincoln included a moral judgment about slavery, saying it was evil, saying that our Republican robe is soiled and that we needed to go back to the spirit of the Revolution, where slavery, in the founders' minds, would have been sort of died out naturally. So my view is that had Webster done that in his 1850 7th of March speech, I would have viewed him more nobly than I do. But I still think that compromise, as Professor Muirhead said, to preserve peace, was certainly something that you can find nobility in.
Well, I won't be as informal as Professor Greabe. I'll address you the way that former professor of government Vincent Starzinger addressed us, which was Mr. Cowderer. Now you're getting a little closer to your paper, I think, and that is I read it to hold Lincoln above Webster for the very moral judgment that you described. And so I think perhaps to repair the damage caused by your paper, I'll ask you this question. What would President Webster have done during the Civil War? And although many nice things were said about Daniel Webster in the previous panel, there wasn't a thing said that would have pleased him more than to hear the words, President Daniel Webster. So would Daniel Webster have issued the Emancipation Proclamation if he were in Lincoln's shoes?
I think, like Lincoln, when the war broke out, Webster would have still tried to compromise or come to some kind of quick conclusion to the war, as Lincoln did. I mean, Lincoln, as you can remember, obviously let the border states continue to have slavery, and that was controversial to many abolitionists in New England at the time. But I think Webster would have tried with a similar approach. I do think that the spirit of what Webster said in 1820 at Plymouth Rock, which is that slavery or the slave traffic should be extirpated from the earth and destroyed, was really his true moral sense of slavery coming through in 1820. And we lose that over time by 1850, where obviously he does not even include a moral judgment on slavery. But I think had Webster had the opportunity to abolish slavery, obviously it's a counterfactual, but I do think he may have had something like the Emancipation Proclamation, but I think he would have been even more vigilant to try to get a compromise than Lincoln had been before that, because Lincoln ultimately decided that emancipation was a noble goal to pursue.
Fine answer. Thank you.
So my favorite moment in your talk was when you say Webster received no applause for his willingness to compromise. And I received a copy of the paper last night, and when I read that, I thought you were speaking metaphorically, and then I discovered a footnote, and you literally meant he received no applause. Nobody applauded for him. So I was thinking of Jeb Bush, I think it was a couple of years ago, saying, please clap now, right? And something similar happened to Howard Schultz recently, right?
That was in Lebanon, actually.
Awesome. But so you called his compromise on the Fugitive Slave Act the greatest act of courageous principle. Professor Muirhead called it, said Webster paid a moral price when it came to slavery. And so just kind of expanding on or pushing back a little bit more on the question that Professor Greabe raised, from the lens of 2019, looking backward, understanding what we understand now, thinking perhaps that there can be no real compromise, right? That maybe in Webster's time we didn't understand somehow that slaves were people, that the natives were people, that everybody was a human being. Do you stand behind that kind of treatment of Webster as hero?
Yeah, so I think that's a great point. And one of the things that we've talked about a lot in this class is that when we're looking at these historical events, we've been sticking to the 19th century context very closely, and like the dynamics between northern abolitionists, southern secessionists, and sort of those who wanted compromise in the middle. So obviously from a 2019 lens, I think it does complicate Webster's legacy, given that he did compromise and compromise his own personal principles and left Union above anti-slavery. But I do think that in his time, it's a bit more nuanced than that, because we sort of suffer from the dangers of hindsight looking back at him today. But I think you do raise a good point, and then we've grappled with that a lot in the class, and it's something that I don't think anyone has been able to give a definitive answer on, unfortunately.
Thank you very much.
Great work. Thank you. Great work. Great work, Josh. Thank you. And gosh, in my zeal to get this panel going, I neglected to introduce the alums who are serving on this panel. 3 professors, 3 Dartmouth graduates, 3 law professors. Starting closest to me, John Greabe from UNH School of Law and director of the Rudman Center. Professor Alexandra Roberts, also UNH School of Law, and expert in intellectual property law. And Professor Tom Barnico at BC Law School, and a longtime lawyer in the Massachusetts AG's office, three-decade veteran of the AG's office, who's argued several times in front of the United States Supreme Court. So thank you so much for coming up and joining us. Let me invite Margaret Cross. Margaret Cross, thank you.
Good afternoon, everyone. My name is Margaret. I will be speaking to you today about my research on Samson Ockham and how his legacy overlaps with that of Daniel Webster. On the surface, the two could not differ more. Ockham was a Mohegan convert to Christianity who spent his life as a Presbyterian minister in missionary work and charitable fundraising. Daniel Webster was the descendant of English settlers, and he established himself not in the pulpit, but as an attorney, congressman, and senator. Yet, Ockham and Webster share a surprising amount of virtues and vices. Both men were gifted orators who used their public speaking to the benefit of Dartmouth. Both were involved in politics, with Ockham serving as a councilman within his Mohegan community, particularly during the Mason controversy, during which he contested the Connecticut colony's claims to Mohegan lands. Both men also professed the Christian faith. Less flatteringly, both men struggled with alcohol addiction and both sanctioned slavery. Webster in his March 7th speech, where he compromised his position on the Fugitive Slave Act, and Ockham in a letter to his mentor, Eleazar Wheelock, requesting to borrow one of his slaves. What connects the two men more than their virtues and vices, however, is their association with Wheelock's great design of native education, which morphed into Dartmouth College. Without both of their efforts, Dartmouth as we know it would not exist today. Ockham raised the funds that allowed Wheelock to build his college in Hanover, and Webster refounded that college through his persuasive arguments in court. However, Ockham and Webster's perceptions of Dartmouth differed vastly. Whereas Webster upheld majority-white 19th century Dartmouth as a literary light that ought to be cherished, Ockham viewed the college with frustration and disappointment. He suspected Wheelock of misappropriating for white students the funds that he had raised in Britain explicitly for the benefit of native students. Ockham's concern with the college's failure to live up to its charitable mission in its earliest years casts doubt on whether Webster was correct to call Dartmouth an eleemosynary or charitable institution during his Supreme Court oral arguments. Ockham also presents us, the Dartmouth community, with a quandary. He deserves to be credited as a co-founder of the college and restored to the center of Dartmouth's narrative, from which I argue he has been marginalized. But on the other hand, his own estrangement from Wheelock and Dartmouth makes it uncomfortable, if not cruelly ironic, to credit him for the college that ignored native students for so long. I conclude my paper by raising the question, how might we honor Ockham's legacy as both a founder and a conscientious objector from Dartmouth? The most important step, I argue, is to listen to his story, and so I will share some of it with you today. In his own words, Ockham, quote, was born a heathen and brought up in heathenism among the Mohegan of New London, Connecticut. At age 16, he became Christian amidst the Protestant religious revival known as the Great Awakening. His mother sought out Wheelock, a Congregationalist pastor and tutor for English youth, and asked him to teach Ockham to read. Wheelock agreed and accepted Ockham into his home, where he studied theology as well as English, Latin, Greek, and French for 5 years. In 1749, Ockham took a position as a schoolmaster and preacher among the Montauk of Long Island, where he remained for 10 years. He was ordained by the Suffolk Presbytery and embarked on a mission trip to the Oneida Indians in 1761 to 1764 on behalf of the Scotch Society for the Propagation of the Gospel, despite the society's fear that the Oneida would kill Ockham amidst the violence of the 7 Years' War. Ockham was willing to risk death to evangelize, writing, quote, I intend to proceed on my journey, and if I perish for want of support, I perish. Ockham's willingness to proceed on his journey and to potentially endure martyrdom reveals the depth of his conviction in his faith and in his goal to evangelize to Native Americans, which he saw crucial not only for their salvation, but also for their survival in the midst of colonial expansion. While Ockham was evangelizing to the Oneida, English preacher George Whitefield recommended to Eleazar Wheelock that he fundraise for his Indian charity school by sending Ockham, a poster child for Native education, to preach in Britain. Ockham and preacher Nathaniel Whitaker set sail for Britain in December 1765, and over the next 2 years, Ockham employed his oration skills to become, as Colin Calloway puts it, Dartmouth's first development officer. By preaching to the British Protestant elite and collecting donations for Wheelock to expand his Indian school in Hanover. Ockham preached 300 to 400 sermons to large British and Scottish audiences. His exotic appearance as the first native preacher ever to appear in England, and his earnest, heartfelt oratory gained him the support of many Brits, and he raised over £9,000 in England and £2,000 in Scotland, comprising the largest amount collected through direct solicitation by any American institution in the colonial era. Unfortunately, upon his return to the colonies, Ockham became disillusioned by Wheelock's neglect of Native education. The college was filled by white scholars and actually turned away some prospective Native students. Ockham felt betrayed by Wheelock and wrote him a scathing letter in July 1771, where he critiqued Wheelock for using him as a pawn to fundraise for his white school, or Alba Mater. He wrote, quote, I cheerfully ventured my body and soul, left my country, my poor young family, all my friends and relations, to help forward your school, hoping that it might be of lasting benefit to my poor tawny brethren. I was quite willing to become a laughingstock in strange countries to promote your cause. But when we got home, behold, all the glory had decayed, and now I am afraid we shall be deemed as liars and deceivers in Europe. You have been scheming altogether. If you had not this Indian bait, you would not have collected a quarter of the money you did. Ockham's letter gives voice to Ockham's pain at having been paraded as a spokesperson for an institution that would never benefit his own people. Wheelock responded to Ockham's letter, but only with attacks on Ockham's unchristian pride and arrogance, and he told Ockham to be grateful for his improving and advantageous tour of Europe. By 1775, Wheelock had spent all of the money Ockham raised in England to build Dartmouth College, rather than spending it on a parallel Indian charity school as he had promised. And due to poor health, Ockham never made it to Hanover to see the college, but his knowledge of Dartmouth's whiteness alienated him from it and Wheelock forever. In conclusion, Ockham contributed self-sacrificially to the establishment of Dartmouth, and every Dartmouth student and alumnus owes him a great debt. Thus, I recommend that as we commemorate Webster this weekend, we also remember fellow orator Samson Ockham and think critically about the Native history of this small and beloved college. Thank you.
Margaret, I really enjoyed this paper so much. It's beautifully written, and it made me feel all kind of warm fuzzies as an alum, thinking about Ockham, learning so much about his role. So I'm going to ask you a super cynical question,
Sure.
which is it possible, is there a reading of this speech, and there are some choice quotes like, I'm afraid we shall be deemed as liars and deceivers in Europe unless you gather Indians quickly to your college. We told them we were begging for poor, miserable Indians. The opinion of many white people about here is that you have been scheming altogether, right? So is it possible that Ockham was less focused, in fact, on the education of Indians and more focused on his good name and his reputation? Because the emphasis in the letter that you quoted from seems to be at least as much about what everybody thinks about him and Wheelock and how angry they will be, and then maybe a glimpse of some papers to come from a contract perspective, the idea that they've been defrauded and they've been let down.
Yeah, that's a great question. I would say that he certainly was concerned with his own perception of having been looked at as sort of exploiting the British donors, but I think that might have been less about his own reputation professionally, because he was a Native American preacher. He was already being sort of objectified by the British. I don't know that he cared as much about his reputation with them as he did about being a Christian and a hypocrite. I think that would have certainly impacted him. I think that contributed to his anger. But he also was sort of scapegoated for and blamed for not having more effectively encouraged Wheelock to use these funds. And actually, John Thornton, who was a British preacher at the time and really advocated for Ockham to Wheelock, insisted that Wheelock had really scapegoated Ockham and blamed him when Wheelock should have been taking more of the blame. So I'm sure there was some fear of his reputation being damaged.
Along the same lines, I just wonder about the charge that Wheelock deliberately misused the funds. Former president of the college, John Dickey, often referred to Wheelock's immense idealistic impulse. And we all know that even some of our best immense idealistic impulses are not fulfilled. And I just wonder whether this is more about a case of Wheelock's failure in the attempt than in a misuse. Is that inconsistent with your conclusions, or would that be just a modification?
Yeah, I think that would be a modification. I actually agree with where you're coming from. I think that a lot of the literature actually suggests that Wheelock tried to educate Native people. His being in Hanover was not an ideal location. He was actually starting to try and recruit Indians from Canada, which wasn't the original purpose. And so he did make some efforts. But to me, what sort of indicts him is we have a letter from Ockham. This is prior to his July 1771 letter, where he says that he has heard about this Native student that went to Wheelock School and got turned away because it was too full with white students. And so I think that we can hold Wheelock partly accountable for this, because I'm sure he could have made room, and the funds were meant for that Native student that got turned away.
So if the case were justly decided, should the Supreme Court have found that, if ever there was a contract, the contract that was written was not in effect in 1819, and relatedly, that the supposed consideration to the king, right, was the edification felt from educating Native youth. That wasn't happening. Consideration is required for there to be a contract. Was the case decided incorrectly?
That's a great question, and one I might leave to my colleagues. But I would just say that I think that just looking at the case in isolation, I think the logic is there internally, but I think that Webster and Marshall do neglect the actual lived reality of the college, and if they had looked and seen how poorly the funds were being managed, perhaps should have reconsidered their argument. Thank you.
Thank you.
Great work, Margaret. Good job.
Margaret queued up Matt Sharon's presentation perfectly. Let me introduce Matt Sharon.
Please bear with me as I attempt to bring out my inner Don Pease over the next few minutes. My name is Matt Sharon, and I'm a senior here, senior history major at the college. And I'll be discussing my paper, which is titled Dartmouth College's Original Sin and the Case for Dartmouth University. And the thesis of this paper really revolves around Dartmouth's charter and the wording of the charter, and the idea that the college was founded, and I quote, "for the education and instruction of youth of the Indian tribes in this land in reading, writing, and all parts of the learning, which shall appear necessary and expedient for civilizing and Christianizing children of pagans, as well as in all liberal arts and sciences, and also of English youth and others." Dartmouth's charter, in a way, established a tripart agreement that was argued to be protected by the contract clause of the United States Constitution during the case in 1819. The university argued that Dartmouth was a public rather than a private institution. As will be explained over the next few minutes, however, if Dartmouth University and its council had illustrated the college's objective failure to execute its contractual obligations of educating Native Americans, a new avenue would have been paved by which the rendering of the opinion of the Supreme Court would have had a drastically different set of opinions. In 1970, President Kennedy pledged Dartmouth's return to its inventive aim. Kennedy's decision to essentially reroute Dartmouth in the framework of its initial purpose acts as an admission of guilt of sort towards its failed aim of educating Native Americans. Between 1769 and 1970, Dartmouth only graduated not even 24 Native American students. This is, to to an extent, still remains Dartmouth's original sin. Dartmouth's charter was granted in the context of a peculiar Native American, colonial American relationship that was spearheaded by the aim and systematic education of Native Americans in the hopes of assimilating them into white culture. This as well as preceding programs and institutions of the 17th century laid the blueprint by which Dartmouth College would be thrusted into in the 19th century. Governor Wentworth, when he signed the charter for Dartmouth, quoted that Dartmouth would civilize the Indians and spread Christianity among them more than any other public or private measures hereto granted for Indian construction. These provisions that I've quoted earlier, as well as this one by Governor Wentworth, root Dartmouth firmly within the 18th century endeavor of educating Native youth. However, as the charter stipulates, the school may be enlarged and improved to include the education of English youth, so long as it did not impede nor prohibit the education of the subjects of its original purpose. This was a tri-party agreement that Wheelock, the Crown, and its original donors had agreed to. Fast forward to the 19th century, which was a very much different Indian-American relationship than the mid-18th century. It was one that was involved with Indian removal rather than Indian assimilation. In front of the Superior Court of New Hampshire and the Supreme Court, the university argued that Dartmouth was a public, not private, institution, given that the very act of educating was a public endeavor. Webster and the college's counsel claimed that Dartmouth was a private, or as we all love the word, eleemosynary, or almsgiving institution. The Supreme Court, as we all know, ruled in favor of the college and agreed with Webster's claim that Dartmouth was a private institution whose contract with the Crown and its original English donors was protected under the Contract Clause of the United States Constitution. Neither argument, however, interestingly enough, discussed or alluded to the role of Native Americans as the primary subjects of its inventive aim. Prior to the conclusion of the case, however, the university appointed William Pinckney as its new councilman. Pinckney attempted to re-argue the case from a new angle and with new facts. Pinckney, if he had not been cut short by Justice John Marshall, planned to bring into question Wheelock's manipulation of the original donors and his diversion of funds from Moore's Charity School to Dartmouth College. This, according to the University Council, would have made Dartmouth a public rather than private institution. But my question is, what if Pinckney and the university had presented his new facts based on the idea that the college had failed to uphold its contractual obligations, thereby voiding the protections of the Contract Clause and allowing the state, which was the new governing body, the opportunity to superintend itself in the college's operations? In order for this to be argued, however, it had to be proved that Dartmouth College had failed to execute its inventive aim. And so it had. By the 1770s, as Margaret alluded to a few minutes ago, the relationship between Sampson Ockham and Eleazar Wheelock had bore witness to the failed obligations of the college. To summarily illustrate Dartmouth's failed aim, here are a few statistics. Not one Native American graduated from Dartmouth within the first 6 graduating classes. Between 1783 and 1806, only 6 Native Americans had enrolled in the institution, with only 3 graduating, all before 1781. At the time of the college case, not a single Native American student called Dartmouth home. In conclusion, it is fairly clear that Dartmouth failed to execute its contractual obligations as outlined in its charter. By 1819, most, if not all, of the original donors had passed, and the English crown no longer maintained dominion over the states of the Union. Given that, it makes sense to claim that it was the duty of the state legislature, the new governing body, to question the validity of the college's agreement. Doing so, based on the facts and claims that I have just laid bare, would have brought into effect several dynamics that would have altered the characteristics of the case that we have all come to lionize and love. Thank you.
So you believe Webster's reputation in this case is completely overblown?
No, not at all.
Because you think it's attributable to the missteps of lawyers acting as assistant attorneys general for New Hampshire. Is that right?
Not necessarily, no. Well, at the time, I'm sorry, that's a good question. At the time, arguing for a more Indian institution within America in its historical context would have went beyond the boundaries, both spiritually, culturally, socially, of America at the time. I think when you take into account the Indian Wars of the first half of the 19th century, and you take into account how America was dealing with slavery, right? There's this perception that both Indians and slaves are second-class citizens, almost subhuman in a way. So arguing for a more Indian American institution would almost be unfathomable at the time.
Well, but lawyers should make such arguments. Why didn't they do it?
And it should have been it should have happened in the lower court too, right? I mean,
Right.
you know, your paper makes the point that Pinckney was sort of cut off.
Right.
But at least by modern standards, and I know that they're quite different, and I don't know, maybe this would have been different, but the whole idea of the lower court is to develop a factual basis.
Correct.
And it does seem remarkable that that this factual basis was neglected by, you know, the equivalent of the assistant attorneys general in New Hampshire, given you know that this was there were some really difficult legal questions that might have been avoided.
Correct.
So you framed this paper in terms of original sin, which I thought was beautiful and incredibly creative. But then you bring the focus around to breach of contract, right? Which is a really different set of tropes and a really different kind of rhetoric. So, so what I want to ask you is, are we doing better? Are we now truer to? Have we come to a place where we're really faithful to that original charter, the goals and the sentiment behind the charter, and are we doing enough?
That's a really good question. I think it speaks to the larger context of America at the time, or at this time. And I think President Kemney's decision to essentially reimagine Dartmouth, right, in 1970, kind of paved this avenue by which Dartmouth would attempt to, as we are doing now and continue to do, return to its, not only its inventive aim, but become more inclusive of minorities across the board, including women. I think at the time in 1970, there's a very interesting dynamic going on in America, right? It's the counterculture movement, which many of you, I'm sure, were involved with. There's the Red Power movement, the Black Power movement, the movement for civil rights. So America is very much engaged in this pursuit, or at least is being pushed by minority groups with a loud voice who want to be included as first-class citizens in this country, right? And I think now, depending on who you ask, there's various ways we can go about that. Have we achieved the ultimate goal? No. But we're very much moving in the right direction, I'd say. Yes, sir.
I'm a member of the class of '63. Somewhere in the back of my rapidly deteriorating I remember the story that the Indians sent Native Americans sent to thank you very much for your great spirit. He works for you people. We have our own great spirit who works for us. Thank you very much. You keep yours, we'll keep ours. Had he not put so much emphasis on Christian conversion, might he have been more successful?
I wouldn't say so. Because if you think about it, right, the Crown and the English donors gave their funds and land specifically for the education and Christianization of Native youth, right? So that was the chief aim. The argument can be made that Wheelock did try, right? The American Revolution kind of caused upheaval within Indian country, per se, right? There was Indian tribes and even Indian clans who were combating, you know, they had kind of combating goals within it. So there was definitely a dynamic going on within Indian country that may have removed the possibility, or I wouldn't say removed, kind of prohibited the possibility of Indians coming to Dartmouth. But at the end of the day, the original agreement was for the education of Native youth, regardless of the circumstances or auxiliary pieces that were going on outside of Dartmouth. I don't know how much time we have left for questions. One more. Yes, sir.
One of the crucial things at this time is, after all, the spread of Americans, the American population from the East Coast westward, stealing the land of Native Americans,
Yes, sir.
to the flow of immigrants. And I think part of the problem is the disjunction between the legal case and that very powerful question of what was happening to the social and economic environment.
Sorry. That's why I brought up earlier the idea that for a lawyer or a court to argue in favor of Native Americans would have almost been unfathomable at the time, because after 1802, with the purchase of Louisiana, the idea of assimilation in the arduous journey of assimilating Indians almost becomes second thought, right? There's land westward that is expendable that we can now push Native Americans out of. So that in and of itself kind of creates this, as I spoke, this aura within the American psyche that didn't necessarily find its way in the case itself, but very much speaks to the larger background of America at the time.
But yet, when the Cherokee removal case was decided in favor of the Cherokees, that did not happen. That the Supreme Court, I think they were.
No, so in 1810, the Compact of 1810, the United States agreed to remove all Indians out of Georgia land at some point in time. Now, Worcester versus Georgia in 1835 or 1830, I believe, set the precedence for Cherokee sovereignty. But regardless, when the Indian Removal Act passed, I think by a very slim margin, and President Andrew Jackson comes to claim, Georgia begins this influx of, I guess you can call it, attacking Cherokee land, right? There's gold found in Cherokee land. And Andrew Jackson in Georgia refused to protect the Cherokees that had the protections of Cherokees that had been established in prior treaties. Given that, I think the Cherokees were placed in between this rock and a hard place in which, yes, there were granted protections under the law, but those protections were not being executed.
They actually won.
They did. But President Jackson also said that Marshall has made the claim, now allow him to execute it, which was obviously the duty of the president. So thank you.
That's brilliant. That's brilliant. Who knew? Who knew You're just warming up, aren't you? I want to take a class with you, Matt. Our next student, our final student in this panel, is actually part of a 3-student team. They're an en banc group of justices who have put themselves in the position of rehearing the re-argument and who have written decisions. From what I understand, it's a 2-1 court. The dissenter, Walker Schneider, we didn't have room to include here. But the Chief Justice, Rachel Inman, is here to deliver the majority opinion. Rachel.
So good afternoon, everybody. So I'm Rachel Inman, and my paper is going to be the majority opinion based on the briefs provided at the re-argument in Washington, D.C. by attorneys Kathe and Greabe. I serve the role as Chief Justice, and 2 of my classmates are doing a concurrence and a dissent. So in this case, we've been asked to consider whether the Royal Charter of 1789, which established Dartmouth College, falls under the scope of the Contract Clause of the U.S. Constitution, and if the 1816 acts passed by the New Hampshire State Legislature were impaired by the Contract Clause. So the New Hampshire Superior Court issued an opinion stating that the charter was not a contract within the meaning of the Contract Clause, and in my paper, I agree with their conclusion. So the first argument that I make is a ruling in favor of the trustees of Dartmouth College would be an incorrect application of the Contract Clause. The opinion first establishes whether the charter is a contract and if it falls within the scope of the Contract Clause. So common law defines a contract as an agreement upon sufficient consideration to do or not do a particular thing. A consideration of some sort is of absolute necessity to the forming of a contract. That an agreement to do or pay something without any compensation on the other side is totally void in law. Thus, the term contract in the Contract Clause is understood to be an agreement among parties exchanging consideration and purchase. The charter of Dartmouth College does not satisfy these requirements of a contract because there's no consideration or purchase. The text of the charter does not provide evidence that the Crown received anything of reciprocal benefit in exchange for granting Reverend Wheelock and the trustees of Dartmouth College certain rights and privileges. The Crown issued the charter for the encouragement of learning and animating of students of the college to diligence and industry and laudable progress in literature, so nothing of benefit moved reciprocally from Dartmouth College to the Crown. Next, I look at a contract clause case precedent that the plaintiffs incorrectly used to support their claim. So they incorrectly used Fletcher v. Peck to support the claim that Wheelock and the trustees received privileges and immunities by simply fulfilling their obligations in the charter, and that this act constitutes mutual consideration. The argument in Fletcher v. Park forms a contract because of the large purchase and valuable consideration, but the charter in the case before us does not have this consideration and purchase, so it does not form a contract. Therefore, we cannot apply the precedent of a case in which the contract falls under the scope of the contract clause to a case in which the contract does not meet the requirements necessary to receive those protections. We should not deviate from contract law by holding that the charter established a contract. Next, the plaintiffs argue that Dartmouth is a private eleemosynary corporation, and they use 2 English cases as support. Dartmouth College is a public corporation, and their claim would require several public corporations to become private eleemosynary institutions in the eyes of the law, and this is an inaccurate understanding of the difference between a private and public corporation. The first case that they cite is K v. St. Catherine's Hall, in which it was articulated that the king is a visitor of St. Catherine's Hall. This precedent runs contrary to the trustees' assertion that eleemosynary corporations are not founded and controlled by government. The second case they cite is Phillips v. Bury, which does not support the claim that Dartmouth College is an eleemosynary institution, because that case said that there are certain institutions that exist for public government, being for public advancement, and that are to be governed by the law of the land without a particular private founder and particular visitor. Thus, this case provides evidence that Dartmouth College is the sort of institution for public government, public advantage, and not having any particular advantage. Thus, it's not a private eleemosynary institution. The text of the charter clearly establishes Dartmouth College as a public corporation and not an eleemosynary institution because of the reason it was established, the role of the state and state officials, and the lack of visitation rights held by the trustees. A textual analysis of the charter leads us to the opinion that the purpose of Dartmouth College is educational, not simply education generally, but the education of youth in the state of New Hampshire. The purpose is very public and falls within the New Hampshire state police powers because the text of the Constitution outlines which powers are reserved to the states and which powers the state cannot lay claim to. Dartmouth College, as a public corporation within the state's police powers, helps maintain the balance of federalism in the country. The power in question in this case is education. Since the Constitution grants states the power over their educational institution through the 10th Amendment, the contract clause does not extend to the case before us because it would unconstitutionally expand the scope of the clause, and it would enable federal intrusion into a scope of state sphere of power. A broad interpretation of the contract clause, which extends beyond contracts to include agreements of civil institutions, is dangerous for the ability of states to exert their police powers over spheres that they have been given power over. What is to stop other reserved powers of the state from being divested? The Supreme Court has never established precedent which limits the state's authority over public corporations over spheres in which they have reserved powers. The second major argument I make in this paper is that even if the charter was a contract, the acts of the New Hampshire State Legislature do not impair the obligations of the charter. This is because the character and purpose of the charter are not changed. None of the alterations made by the acts of 1816 change the character or purpose. The change in name, increased number of trustees, and the creation of the Board of Overseers all further the purpose of the college to educate youths in the state of New Hampshire. The text of the acts clearly show that the trustees maintain their rights from the charter. They just simply make small alterations to update the charter to ensure that the college is able to keep extending opportunities and advantages of education. The purpose of Dartmouth College, education, is the same before and after the acts of the New Hampshire in 1816. The character of the college, which is carried out by the corporate board of trustees, is the same and even improved to better execute the purpose of the college. Finally, the state of New Hampshire has always had a role in the corporation. The charter recognizes that the school was established as a corporation entitled Dartmouth College for the benefit of the state of New Hampshire. Second, the charter specifically names a set number of citizens from the state of New Hampshire to be on the board of trustees, and then it specifically states certain public state officials to be trustees. The desires and citizens of the state of New Hampshire in the governance of Dartmouth College is not a new phenomenon, but rather a continuation of the state's pre-existing role as outlined in the charter. Therefore, it would be counterintuitive for the acts passed by the people of New Hampshire through their state legislature to impair the obligations of a charter in which they have an explicitly defined role in.
First, let me congratulate you on your appointment as Chief Justice.
Thank you.
I'd like to suss out, to use this case to suss out a little bit more your approach to constitutional interpretation. Is your argument that the contract clause is better understood because it would have been understood at the time it became law not to apply to this case? Or is your argument, in a more forward-looking way, that it is better, as we look forward, not to understand the contract clause to preclude the state from doing what it did here?
Yeah, so that's a really good question. I think what makes going through this case difficult is not having that forward-looking approach. And I think for me, part of my constitutional interpretation is definitely shaped by the fact that this broad understanding of the contract clause that came from this case has enabled a broad range of rulings on corporation, giving corporations a lot of protections. So I think for me, in looking back at a lot of the original text, I kind of was interested to see if there was a way to read it that would have had a more narrow application of the contract clause, being kind of rooted in the text of the time.
I really enjoyed this, and I thought it was a very cool exercise and reminder that I think in some ways sets the tone for the rest of today and tomorrow, that the outcome of this case was not a foregone conclusion. And as much as we talk about the lawyering and the oratorial skills, it didn't just rise and fall on the lawyering, right? It fell on interpretation of the law. So I just wanted to push back a little bit on your arguments about consideration and the lack of consideration. So when the king grants charters like this, there's got to be something in it for the king, right? And I think there are a few ways to think about that. One, a general one, might be loyalty. A more specific one might be thinking about this commitment to educate both the colonists and the Native Americans, and then as we heard earlier from several of your colleagues, the goals of Christianizing, the goals of civilizing the Native Americans, while at the same time educating the colonists. So I think there's a lot there. And it surprised me to hear you come out so clearly on the side of there's simply no consideration. This is a one-sided deal, and therefore the charter is not a contract.
Yeah, no, that's a really good question. I think something I was thinking about is this idea of kind of the king receiving consideration through benevolence. But I guess in looking, I kind of took a very strict reading, and I guess through that lens, I found it kind of difficult to use text and I guess the common law at the time to kind of support how do you in words and legal precedent kind of show and support benevolence, and what's the precedent that you're going to use to support that, and if you come down as benevolence as consideration in future cases, how lenient can that be?
Yeah, I don't know that benevolence is consideration, but consideration, at least in modern contract law, is an extremely low bar. It can be minimal, it can be tiny, but it's usually not a gift. It's usually not benevolence. So it's an interesting issue. Thank you.
I'm interested in your argument about the college as a public institution. That was your argument, and it seems that your rationale is that it was providing a public benefit in the form of education. Well, doesn't that mean Webster was right? Doesn't it mean that the Jeffersonian inclined legislatures could run roughshod over every private educational institution at the time, turning their lights out, in the metaphor he used?
Yeah, so I think that was an argument that I definitely struggled the most to provide a counter with, especially thinking about now the role of education, higher education being a lot of public institutions, a lot of private institutions. And I guess that could be potentially the danger of an opinion of mine, would be that potentially states could come in and have a say.
Or tax endowments.
Yeah, but I think
throw something out.
the biggest part for me was the strong role that the state of New Hampshire had played since the beginning in Dartmouth College, and maybe that could be the line that you draw, is in states that have not had any role in an educational institution's history, them coming in would be a little bit different than the state of New Hampshire coming in.
Rachel, thank you.
Good work. Good work.
I think Rachel has prepared us for the re-argument that will commence in 15 minutes in the auditorium. I would like to thank you for so generously commenting. I'd like to thank the students for their brave presentations. Josh, Margaret, Matt, and Rachel. Thank you, Tom. Thank you, Alexandra. Thank you, John.